Frekhtman, a New York City personal injury trial lawyer, and today I'm here with a video I watched on Instagram. And I want you to watch this video and tell me what you think.
Which was pretty good because this was a jury trial, as was Truman. This was our second jury trial, just finished it last month. A guy that was probably negligently killed, but we kind of made it look like other people did it.
This is a video where a defense attorney who is the owner of a defense law firm hired by the insurance company to defend a wrongful death trial. So it was a car crash and there was a trial. And the defense attorney is talking to his staff. They actually won the trial. It was a 12-0 defense verdict.
And we actually had a death certificate that said he died the very way the plaintiff said he died, and we had to say, no, you really shouldn't believe what that death certificate says, or the coroner from the Orange County Coroner's Office who says it says what it says.
But what he says in the video is very disturbing because he's admitting that the plaintiff was probably negligently killed. And that evidence is confirmed by the coroner's office and by the very death certificate, right? But his attorney that tried the case, I think her name was Esther, he's congratulating her, he's ringing a bell saying, congratulations, because we socked it to 3 lawyers in the face and we told the jury that it was caused by other people. So basically, that's what the defense tries to do in a lot of cases. They try to stir confusion, right? And bring up like these doubts in the minds of jurors. But here it's so egregious, it's to the point where the defense lawyer knows he's in the wrong, that the plaintiff was negligently killed, which would make it a wrongful death case that has merit, and this particular individual that was killed, his family deserves justice. They deserve compensation for his pain and suffering, and this lawyer is celebrating a win, saying ridiculous things like we socked it to 3 lawyers in the face, we made it look like other people did it.
Overcoming all of those hurdles, we managed to sock 3 lawyers in the face, and it was the fastest defense verdict Esther's ever gotten, and it's the fastest defense verdict I've ever gotten, and it was a 12-0 defense verdict in 26 minutes. So here, Esther, go ahead and ring the bell.
So that really borders on the edge of what ethics and advocacy. I mean, you, as a lawyer, you always want to advocate for your side, but there are certain boundaries. If you know something is wrong, you can't really advocate for it anymore. And then the other part of the video, he talks about somebody else, another lawyer in his firm, that was able to get a felony conviction out of evidence. And I think what he means is that his driver, probably like the driver of the truck, the defendant that he's representing, had a felony conviction, and then the trucking company hired him anyway, and then this was the truth, right? He did have this felony conviction, but somehow through a legal technicality, he was able to keep it out of evidence. And that kind of brings up the question of how judges control the ultimate outcome of a trial. Because if you have one judge, the judge may allow it into evidence, and then if you have another judge, the judge may say, you know what, I'm not going to allow it for whatever reason. So judges and lawyers, if you have one lawyer that researches the precedents and the rules of evidence a little bit more, they might get it into evidence. And then if you have another lawyer that just is a little bit lazy or it's a little bit researches the wrong thing, then you keep it out.
Frekhtman, Truman, well done.
Woo!
And virtually Andrew. Andrew's going down to argue. Andrew had to keep our client's felony conviction from getting introduced at the time of trial. That's where the bell ring on its own.
Andrew! Woo!
So he's celebrating this, but I really think it's just disgusting because fundamentally at the core truth, if he looks himself in the mirror and asks himself brutal honesty, like, how do I go to sleep at night knowing that this poor man was negligently killed, his family is supposed to receive compensation, whether it's a lot of money, a fair sum, or a little bit of money. but you're celebrating the fact that you know somebody was negligently killed due to the negligence of your policyholder, your client, and you're ringing a bell saying that your lawyers did a good job. So I think that just goes against every ethical standard and every rule in the book. And furthermore, this whole idea of ringing the bell, right? So us plaintiffs' lawyers, we are always competing with defense lawyers, and a lot of the defense lawyers are very friendly. We go out, we have lunch together, we have dinners together. Defense lawyers invite us to their legal education program. Sometimes we invite defense lawyers to some of our legal education programs. But I remember this phrase too, like one time I was working on a case and the defense lawyer from a big white shoe firm with like 500 lawyers called me up and he said, "Oh, what's your demand on this one?" And I said, I think this case is worth whatever it was, I don't remember, a lot, it was significant, $850,000. And then he used that same phrase. He said, "Oh, you think you're going to ring the bell on this one?" And I never really look at it that way. I don't think of it as ringing any kind of bell. I think about it as representing my client, right? Representing a serious injury victim and doing whatever I can for that serious injury victim and his or her family, right? Real people, representing them, getting to know them, go to their house, break bread with them, do the best job you can do for them. Sometimes that'll mean a settlement. Sometimes that'll mean a jury verdict of $10 million or more. Sometimes that'll mean a defense verdict like these guys got. But I never celebrated that way. I socked it to the defense. I tricked them. I defrauded them because I would never do that. It's just not who I am. And I don't think it really should be who any lawyer is.